Dear Commissioners, we proudly present to you our project,
Harmonization of Road Traffic Liability Rules in the European Union.
We would like you to hear our proposal upon the subject matter and have an open eye for our justifications.
As Jean Monnet, one of the founding fathers of the European Union, once said, "Make men work together. Show them that beyond their differences in geographical boundaries, there lies a common interest." Now, before we jump to the legal rules and reasoning, picture this scenario.
Brian, a father of 3 and a husband to a very demanding wife, had just left work, mentally listing on what he has to do before going home. He already forgot the first errand, picking up the kids from school.
Trying to abide by the speed limit, Brian takes a shortcut on a quiet non-residential road. Out of nowhere, Nathan, a university student, is rushing to his 4 p.m. tutorial on his bicycle. The only way for him to reach his destination on time, he would be required to cross all roads without stopping, not even for a second. Now you can imagine what happened next. Yes, you guessed it. Nathan crossed the road at the same point Brian drove by, resulting in him hitting Nathan before he could think of slamming his brakes.
Long story short, Nathan was diagnosed with traumatic inner head bleeding, a few broken bones, and a very expensive hospital bill. Brian ended up having his car being a total loss after colliding into a wall as well.
Now, the question arises, who was at fault, and who owes compensation to whom? Nothing is all lovely and dandy in the 3 jurisdictions.
English common law deals with road traffic accidents under the tort of negligence. The accumulative rule to establish fault liability of the defendant is first that at the time of the accident the defendant owed the claimant a duty of care. In the Nettleship v. Weston case, the court ruled that the threshold for the duty of care is set higher upon the subject matter. Driver's conduct is compared to that of a careful and skilled driver. Second, there must be a breach of this duty, meaning the defendant was not sufficiently careful in his actions. Lastly, there must be a serious damage having been caused by the breach of the duty. The claimant in this case would be Nathan, since he suffered the more severe damage. He then has to bear the responsibility of showing that Brian had breached his duty of care as an experienced and careful driver. This will not be easy to establish, given the defense Brian could invoke, namely contributory negligence. Contributory negligence takes into consideration the acts of the claimant in the accident, and when used respectively will result in lowering the damages, meaning the cost of the damage caused. If, for instance, Brian had been on the phone with his wife at the very moment Nathan was crossing the road, or had been for any other reason distracted, then contributory negligence could be easily invoked. And although Brian could have technically been at fault in that scenario, Nathan would receive lower compensation due to his own negligence.
In Germany, traffic accidents are dealt with under the Road Traffic Act. It distinguishes between the driver and the keeper of the vehicle. In many cases, the driver and the keeper will be the same person. When, however, these are 2 different people, the applicable rules will differ also. Paragraph 18 stipulates that the driver of the motor vehicle involved in an accident will be deemed liable for the damage caused, unless he can prove that he was not at fault. This reverse burden of proof is the strictest form of fault liability, in which the fault of the defendant is assumed at the starting point. The burden of proof is shifted from the claimant to the defendant. Similarly to English law, contributory negligence of the victim may play a role here. Paragraph 7 of the Road Traffic Act holds that the keeper of a vehicle which caused death, physical injury, or property damage will be strictly liable for these damages because of the operational risk of the vehicle. Strict liability is defined as liability regardless of fault. The leeway to escape liability as the keeper of a motor vehicle is the defense of an external cause, and contributory negligence could once again serve as an instrument for lowering the damages to be paid. Furthermore, if the keeper and the driver are different people, then the claimant can initiate separate tort proceedings for compensation of the damage against both actors. Looking back to the accident that happened between Brian and Nathan, Brian can indisputably be held liable as a driver, since at the time of the accident he had control over the vehicle. Depending on whether he owned or leased the car, he could also be liable as the keeper under strict liability. However, if the car belongs to Brian's cousin, and Brian only borrows it, then Brian's cousin could be strictly liable as he is the keeper. In either case, the defense of Nathan's negligent contribution to the accident, crossing the road on a bike at a high speed and without a helmet, would reduce the compensation he would receive for his medical bills. The French tort system is amongst the strictest rules on road traffic liability in Europe. The nearly absolute judge-made law, Loi Badinter, does not require intentional conduct from the tortfeasor to deem him liable for the damage. The highest level of protection is attributed to pedestrians, cyclists, and passengers. The driver involved in accidents with these actors can use the defense of intentional conduct or inexcusable fault of the victim. However, the latter can only be used against victims between the ages of 16 and 79. With regards to a driver victim, strict liability will apply unless it can be proven that this victim has contributed to the occurrence of the accident. In this case, the amount of damages attributed will be reduced, meaning that there is an undertone of fault liability. However, as held by the French Supreme Court, it cannot be implied from this that in situations where the victim driver was the sole cause of the accident that he will not be compensated. One of the reasons Loi Badinter was introduced was to quicken bringing the compensation to the victim. Instead of having to prove the defendant's fault, the victim need only prove causation and damage. In fact, this is the main reasoning behind the use of strict liability in road traffic accidents, not only in France, but also elsewhere in Europe. This strict French approach would give a drastically different outcome to Brian and Nathan's case. Given that Nathan was a cyclist, he would be granted more protection than Brian, a driver of a motor vehicle. The only defense Brian could use, intentional conduct of Nathan or inexcusable fault, have been interpreted very narrowly by the court, and Brian will be still liable for Nathan's damage. That is why the French traffic liability regime is often referred to as almost absolute liability for vehicles.
The notion of third-party insurance for traffic accidents in France had been introduced in 1957, long before it was regulated on the EU level. This was to secure the victim's compensation for the suffered damage.
When dealing with the EU, the member states are founded on shared values, including non-discrimination as stipulated in Article 2 TEU. The different outcomes stemming from varying national approaches towards traffic liability built up to inequality of how the defendants and claimants are treated amongst member states. Thus, the differing liability rules are against the ideals that the EU is founded upon. Since each of the discussed systems differ in establishing traffic liability, the victim cyclist would receive most compensation under French law, less under German law, and little or none under English law. Fault and strict liability as notions on their own are opposed. According to Legrand, the notion of legal mentalite originates from the various cultures which make them irreconcilable. However, behind the surface of various legal techniques, similar principles, goals, and preferences hide compensation of damage. By focusing on these underlying principles instead of the peculiarities of the legal system used, the economic analysis of tort law can contribute to bridging the unbridgeable. With the progress of time, the line that separates law and economics slowly fades away. Several theories have been made apparent along with numerous publications upon the subject matter. Law and economics can show that although there are important differences between legal systems as far as a specific legal technique is concerned, the underlying economic balance of interest and preference can often be similar. Thus, by focusing on the functions and goals of liability law in the various legal systems, law and economics may, by merely scrutinizing the legal techniques which are used to achieve a specific result, show that differences between some legal systems are not huge as one may at first sight believe. Differences between the legal systems are further articulated in Helmut Wagner's economic analysis, which dives into the skepticism that national law create not only subjective uncertainty but objective uncertainty when it comes to the cross-border rationale in the EU. If legislation is different, the cost for industry would differ as well, and the conditions of competition within the common market would not be equal. This argument on its own will alarm the Commission, favoring harmonization.
The EU has produced directives imposing mandatory insurance for damage caused to third parties in traffic accidents. Even though there are these directives which member states should implement in their national legislation, insurance in the member states is not on the same footing because of the different forms of liability that can occur. This difference adds on to the inconsistency of traffic liability rules despite the enactment of a single mechanism to compensate the harm, the directives. As previously shown, compensation systems differ across member states. The differences are present both in terms of substantive rules on liability, causation, and loss, as well as procedural issues around advancing a claim, for example, different trigger events for limitation purposes, and reaching settlements. As we observed, some member states use compensation systems which are based on negligence, while other member states use strict liability systems. This is a significant difference, which has an impact on both claims handling procedures and claims costs. Insurers have to assess the local environment into which they wish to sell in order to price their products based on the risk analysis. Although this analysis would obviously include the local contractual law, it will be based on the wider local legal and regulatory framework. There is a need for local presence, and it is even taken into account in the EU legislation. In a market as competitive as motor insurance, an insurer seeking to offer motor insurance products Europe-wide would require separate market expertise and information for risk calculation and pricing in each member state, as well as pricing systems which have been adapted for each country. It should be noted that there exists significant risk differences not only between member states, but also within national markets. These differences inevitably create disincentives to direct cross-border insurance trade, hindering the free movement of services. A harmonized approach with regards to liability rules would be a step forward for facilitating the functioning of the European insurance market. This would give the smaller insurance companies an incentive for cross-border expansion, which in turn would provide European drivers with more beneficial insurance opportunities, as having a wider range of insurance to choose from. When can the Commission act? The EU can act in limited areas in which the member states have given up their sovereignty. The EU can act exclusively when the subject has to do with the internal market. Nonetheless, the subsidiarity principle has to be taken into account. At this point, we are advising the Commission to create a single legislation on traffic liability, similar to the soft law for contract law, the DCFR. With this conception, the 180-degree difference between liability based on negligence and strict liability will be erased, creating clarity. The member state will take the law as a point of departure. Austria has already replaced its private law and based it on the principles of European tort law, as presented by the European Tort Group. This initiative corresponds to the Ali Uni Droit international organizations aiming for the unification of the private civil rules.
These principles aim at creating a set of procedural rules and values that will be adopted globally to transcend national jurisdictional rules and facilitate the resolution of disputes arising from transnational commercial transactions. This work strives to reduce uncertainty for parties that must litigate in unfamiliar surroundings and to promote fairness in judicial proceedings.
We thank you, dear Commissioners, for your time and respectfully request that you review our proposal on the harmonization of tort law in the European Union.